Today we will be discussing the New Mexico Pregnant Worker Accommodation Act and the Federal Pregnant Workers Fairness Act. My name is Haley Zock and I am the staff attorney at Southwest Women's Law Center. Today we will begin by going over our legal disclaimer. The information provided in this presentation is for informational and educational purposes only. It is not intended to be and should not be construed as legal advice. The content presented herein may not be applicable to your specific situation, and reliance on it should be undertaken at your own risk. Always seek the advice of qualified legal professionals regarding any legal issues or concerns you may have. No attorney-client relationship is formed by accessing or using this presentation. The presenter and creators of this presentation disclaim any and all liability for any actions taken or not taken based on the information provided today. Okay, let's start off with an overview of the laws that provide pregnancy protections at work. We'll start with the federal laws, and those include Title VII of the Civil Rights Act of 1964, which prohibits discrimination based on pregnancy, childbirth, or related medical conditions. And then we have the Americans with Disabilities Act, you may know it as the ADA, and this states that while pregnancy itself is not considered a disability under the ADA, complications related to pregnancy, such as pregestational diabetes, may qualify for accommodations. And then the newer federal law is the Federal Pregnant Workers Fairness Act, or PWFA, and this specifically focuses on ensuring accommodations for pregnant workers. And then in New Mexico, we have the New Mexico Pregnant Worker Accommodation Act, which speaks for itself, but we will get into that. So you may have noticed that two of the laws that I just discussed seem to cover the same thing, accommodations in the workplace related to pregnancy and childbirth. You might be wondering then how federal and state laws coexist. Well, federal and state laws often address similar issues, but they can coexist due to the structure of the United States legal system. Federal laws can preempt or override state law, but they can also operate at the same time without conflict. For example, the Federal Pregnant Workers Fairness Act sets a minimum standard for protecting pregnant workers, and the New Mexico Pregnant Worker Accommodation Act adds to these minimum standards. So the federal law states that an employer who has at least 15 employees is prohibited from discriminating based on pregnancy, childbirth, or related medical conditions. And the New Mexico state law says the same thing, but it applies to employers who have at least 4 employees. So this means that more employees are covered under the New Mexico law than would be for the federal law, because the threshold for the number of employees for the employee to be covered by the law is lower. Both federal and state governments have their own law enforcement agencies, courts, and administrative bodies, and they enforce their respective laws independently, but sometimes they can collaborate on joint initiatives and work together when laws address similar things. Let's delve into the Federal Pregnant Workers Fairness Act. It was passed in June of 2023, and it requires covered employers to provide reasonable accommodations to a worker's known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship. And this basically means that the employer is saying that it's far too expensive or far too time-consuming to provide that accommodation. The Pregnant Workers Fairness Act filled in gaps present in the other laws we discussed, the Americans with Disabilities Act and Title VII. Title VII accommodates pregnant people only if other people similarly situated receive that treatment, which is limiting. And the American with Disabilities Act accommodates pregnant people only if the worker's pregnancy conditions amount to a disability. And this new law, it is enforced by the EEOC, or the Equal Employment Opportunity Commission. The Federal Pregnant Workers Fairness Act prohibits employers from requiring an employee to accept an accommodation without a discussion about the accommodation between the worker and the employer. They can't deny a job or other employment opportunities to a qualified employee or applicant based on the person's need for a reasonable accommodation. They can't require an employee to take leave if another reasonable accommodation can be provided that would let the employee keep working. They cannot retaliate against an individual for reporting or opposing unlawful discrimination under the Pregnant Workers Fairness Act, or by participating in a Pregnant Workers Fairness Act proceeding, like an investigation or filing a complaint. And they can't interfere with any individual's rights under the Pregnant Workers Fairness Act. Now let's go over the New Mexico Pregnant Worker Accommodation Act. It was passed before the federal law in March of 2020, and it amended the New Mexico Human Rights Act to add protections for pregnant workers. It mandated that employers must provide reasonable accommodations for employees or job applicants who require them due to pregnancy, childbirth, or related conditions. It defines a reasonable accommodation as a modification or adaptation of the work environment, work schedule, work rules, or job responsibilities, and reach through good faith efforts to explore less restrictive or less expensive alternatives to enable an employee to perform the essential functions of the job, and that does not impose an undue hardship on the employer. Under the New Mexico Pregnant Worker Accommodation Act, employers are obligated to provide reasonable accommodations unless doing so would cause significant difficulty or expense, which is referred to as an undue hardship. So these accommodations may involve, as we discussed, adjusting your work environment, schedule, rules, or duties, and this may include help with lifting, light duty tasks, or periodic breaks for hydration and rest. Employers are expected to engage in sincere discussions with you to identify suitable accommodations, and they may also explore alternative options that are less restrictive or costly while still allowing you to fulfill your job's essential functions and without imposing that undue hardship on their operations. You cannot be forced to take leave, paid or unpaid, if reasonable accommodations can enable you to continue working safely unless you willingly opt to leave or it's required by federal law. Under the New Mexico law, it is unlawful discriminatory practice for an employer to refuse or fail to make a reasonable accommodation for an employee or job applicant with a need that arises from pregnancy, childbirth, or a condition related to the pregnancy or childbirth. It's also unlawful discriminatory practice for an employer to refuse to hire, to fire, to promote or demote, or to discriminate in matters of compensation, terms, conditions, or privileges of an employment against any person otherwise qualified because of pregnancy, childbirth, or condition related to pregnancy or childbirth. And this can be seen as, say, an employee approaching their employer and asking for a chair to be put at the checkout where they do their work because they're having trouble with their feet, maybe due to their pregnancy. And if their employer in some way fires them or demotes them for making this request, this can be seen as unlawful discriminatory practice. Also, if, for example, your work allows 2 work-from-home days per week, and you traditionally haven't used any of those work-from-home days, you're just an in-office type of person, and then you get pregnant and you decide based on your medical condition or your pregnancy that you'd like to then utilize those 2 days a week work from home. That's a privilege provided to everyone at work, and you're denied this because of your pregnancy, childbirth, or a condition related to the pregnancy or childbirth. This can be seen as unlawful discriminatory practice. It's also unlawful discriminatory practice for an employer to refuse to admit or employ any person in any program established to provide an apprenticeship or other training or retraining because of pregnancy, childbirth, or condition related to pregnancy or childbirth. And it is also unlawful discriminatory practice to print or circulate or cause to be printed or circulated any statement, advertisement, or publication, or in any type of the forms for employment or membership that an employer might have, for them to have discriminatory statements within those that are based on pregnancy, childbirth, or a condition related to pregnancy or childbirth. And then, as we previously discussed, employers cannot retaliate against an individual for reporting or opposing unlawful discrimination and cannot interfere with an individual's rights under the Act. So if an employee goes to their employer and says, hey, I think I'm going to be filing a complaint with the Department of Workforce Solutions, and the employer says, if you do that, I will fire you, this is seen as retaliation, and that can be unlawful discriminatory practice. So now that we've covered both the federal law and the New Mexico state law, you might notice these sound the same, and it's true. They both address accommodations for pregnant workers. There are some differences, though, that I do want you to keep in mind, and the one is that covered employers are different under the federal law and the state law. As we discussed, the federal law covers employers who have 15 or more employees, but the New Mexico law covers employers who have only 4 or more employees. So in the state of New Mexico, the New Mexico law is going to cover more employers than the federal law would cover in New Mexico. And then also there's a difference in where these laws apply. The federal law, of course, it applies nationwide, so a complaint can be filed in any state under the national law. But the New Mexico law only applies to New Mexico. And again, it only applies to those employees whose employers have 4 or more employees. So what does this mean for you? Well, because New Mexico law includes the federal law but provides additional protections or covers more employees, you can file complaints with the agencies in New Mexico. If your employer has more than 4 employees but less than 15 employees, the New Mexico Pregnant Worker Accommodation Act applies, but the Federal Pregnant Workers Fairness Act does not. We're lucky here in New Mexico that if you do file a complaint with our agency, which is the Department of Workforce Solutions, that complaint will be dual filed with the federal agency. If you have more questions in regards to the complaint process and how to file a complaint and what happens in that process, please see the other video in this series about complaints, and it'll be found on the Southwest Women's Law Center YouTube page. Thank you so much for joining me today. If you have any follow-up questions or comments you'd like to make, feel free to reach out to me via my email address or by giving our office a call. You can also check in with Southwest Women's Law Center on our Instagram page or our Facebook page.